Hello, welcome to our evidence subject. Now I will begin by discussing the importance of this subject to you as criminology students. Now we all know that criminology is the study of crimes, and as criminologists we play a part in putting those persons who have committed a crime to justice. But how do we put a person who committed a crime to justice? By securing a conviction in court against him or her. And how do we secure a conviction? By presenting evidence in court that he or she really did commit the crime. Now, the evidence subject, or that is where the evidence subject comes into play. So, in this subject, we will know whether a particular evidence, may it be object evidence, documentary evidence, or testimonial evidence, we will know whether it is admissible or acceptable by the court, because not all evidence that we think is relevant to the crime can be or will be admissible in court. Okay, so if we know whether a particular evidence is admissible or not, then we can, as criminologists or investigators, we can now look into the proper places to find a particular piece of evidence. And if we know where to look for that particular piece of evidence that is admissible in court, then our job as a criminologist or investigator will become easy, and we will become efficient in doing our duties and responsibilities. Now, in this subject, we will primarily discuss, or our primary source of our discussions will be the 2019 Revised Rules on Evidence, which is a part of the Rules of Court promulgated by our Supreme Court. However, this 2019 Revised Rules on Evidence is not the only source of our rules on evidence. We have other sources like the Rules on Electronic Evidence, which deals primarily with those evidence involving electronic factors like our cell phones, computers, so in social media. And we also have rules on DNA, rules on DNA, and other relevant rules to evidence. But again, our primary source, or we will be, in this subject, we will be primarily dealing with the 2019 Revised Rules on Evidence. So now let us proceed to our subject proper. So the Revised Rules on Evidence begins with Rule 128 regarding the general provisions. So first, let us define what is evidence. Okay, so remember here that we are defining evidence in a technical or legal sense. Okay, so evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. So like if we want to establish that A murdered B, we have to present evidence showing that A killed B. And the definition also says ascertaining in a judicial proceeding. So if a certain evidence is not or will not be used in court, for the purpose of our subject, it will not be considered as evidence. And also the definition says sanctioned by these rules. So evidence on how it will be presented or whether it will be admissible in court or not will be governed by this 2019 rules on evidence. Now, in relation to the term evidence, we have to learn about these two basic concepts, the factum probandum and the factum probans. The factum probandum is the proposition to be established, while the factum probans is the material evidencing the proposition. In other words, the factum probandum is the fact, the truth of which is to be determined. Okay? While the factum probans is the evidence that will show whether the fact to be determined is true or not. Okay, so for example, in a rape case, the prosecution, where we criminologists belong, wants to establish or has a proposition that A raped B. Okay, so that is the factum probandum. We want to establish in court that A raped B. So how do we prove that? Okay, how do we establish that? By showing our factum probans. Our factum probans is that the semen matching the DNA of A is found in the vagina of B. So that is our factum probans, or our evidence that A raped B. Now let us proceed to section 2 on the scope of our revised rules on evidence. The rules of evidence shall be the same in all courts and in all trials and hearings except as otherwise provided by law or these rules. So it is just saying that these rules, our revised rules on evidence, will be applied in all courts, whether in the municipal trial court, regional trial court, court of appeals, and the Supreme Court, and in all trials and in all hearings. The rules on evidence are these rules on evidence shall be applicable, except if the law or the rules will say otherwise. If there is a law or the rules, these rules itself say that the ordinary rules on evidence under these rules will not be applicable, then the rules will not be applicable. Now let us proceed to section 3. Now this is perhaps one of the most general concept that we must remember regarding the admissibility of evidence. Now, evidence is admissible when it is relevant to the issue and not excluded by the Constitution, the law, or these rules. So this section here is telling us in order for a particular evidence to be admissible, it must be relevant to the issue and it must be not excluded by the Constitution, the law, or these rules, these revised rules on evidence. Okay, so there are two requirements in order for an evidence to be admissible in court. Okay, it must be relevant and it must be not excluded by the Constitution, the law, or these rules. Or in short, it must be competent. Okay, so again, we must remember, in order for an evidence to be admissible in court, it must be relevant and it must be competent. Again, if we say competent, it is not excluded by the Constitution, the law, or the rules on evidence. Now, what is this admissibility? Okay. Now, when we say that an evidence was admitted by the court, it just means that the judge, in determining whether a certain proposition is true or not, okay, in deciding whether the factum probandum is indeed true or not, the evidence that is admitted will be considered. Okay? While when we say that the evidence is not admitted by the court, it just means that the evidence will not be considered by the judge in determining whether the factum probandum or the proposition is true or not. Okay? It's just the evidence will be considered or not considered. If we say the evidence is admitted, the evidence will be considered, but the evidence will not be admitted, then the evidence will not be considered. Now let us proceed with section 4 on relevancy and collateral matters. Now we have said before that one of the requirements in order for an evidence to be admissible is that it should be relevant. Now this section 4 here defines when is evidence relevant. It says here that evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. So it means that an evidence is relevant to the fact in issue if it has a relation to such fact in issue as to induce belief in its existence or non-existence. So in here, really it's reason or logic which must be used. Okay? According to the Supreme Court, there is no precise and universal test of relevancy provided by law. However, determination of whether a particular evidence is relevant rests largely at the discretion of the court, which must be exercised according to the teachings of logic and everyday experience. Okay, so there is really no rule about it when or how can we determine such if the thing is or the evidence is relevant or not. Okay, but we must just remember if the evidence induces a belief into the existence or non-existence of a fact, then our logic and reason will tell us that that evidence is relevant. Now, regarding collateral matters, according to this section 4, evidence on collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. So for example, example of this evidence on collateral matter is motive or reputation. Now that concludes our discussion on Rule 128 General Provisions.